Good afternoon. Are you able to hear me?
Yes, sir, you are audible, sir. Please.
Thank you very much. So let us get bored from my lecture. Now this lecture is on professional ethics, as you know. I am sure you people must have seen the syllabus which is given to you for this paper. It is very important. Please go through the syllabus so that you are able to know what topics have to be covered. See, as you know, our legal profession is one of the greatest learned profession, and therefore we are required to have knowledge about everything, all aspects, as we have to deal with variety of human relations. Now that depends upon where you practice, what type of matters you get, as water tribunals are different, electricity tribunals, consumer forums, etc., all types of tribunals. Now, some advocates, they concentrate on these tribunals and build their practice. So it is necessary that those advocates get fully tuned with regard to all those subjects on which they have to concentrate. Now, in professional ethics, you would necessarily, you have to keep in mind that the judges observe you when you enter the courtroom, when you sit there, when you talk, when you leave, your behavior with the other advocates. The judges from there, they watch you. Like, one of the tour managers once told me that when we assembled for the tour for going abroad, the tour manager used to sit at a corner and watch every person who was to join him. And he said that when I see these you people coming, I am able to form an opinion as to how this person would be. Like that, the judges also, they know, they watch, and they observe. And therefore, your conduct inside the courtroom is extraordinarily important in the profession. Therefore, you must see that you are properly dressed. You don't unnecessarily talk. You concentrate on what the judges are saying, as even the Chief Justice is in his latest speech. He told us that Nariman, when he was, the Chief Justice was briefing Nariman, he said, when the judges talk, you keep quiet so that you know what exactly is passing in his mind. That is the time when you have to concentrate the most. Likewise, sitting in the court gives you lot of advantages. I don't know whether I am visible because my computer shows sometimes so many things. So lawyer is a peacemaker. He also acts as a mediator. As you all know, section 89 of the CPC, which has been introduced now, you have to mediate to see that less number of cases go to the court. Recently, the Chief Justice of India also said that more than 60% of the litigants are either state governments or Union of India. And therefore, they must see that the litigation where one of the parties are either Union of India or different states, they should try to settle the matter. But this doesn't happen because first Rangnath Mishra, when he became the Chief Justice of India, he tried his best to see that this is given effect to. But ultimately, who can bail the cat is a very different proposition, and nobody wants to take risk. Be that as it may, our profession, we are required to acquire a lot of knowledge. And therefore, it is necessary that we actually work very hard on the brief. Now, some of the seniors who are no more with us, like P.P. Rao or Shanti Bhushan, whenever you go to them for conference, whenever you brief them, you would find that they will start from the beginning, as if they are sitting for the first time on the brief. And they will have their notes rewritten. So once when I had gone to one of them, I asked him, "Sir, you have already taken out a note and you have prepared a list of date. Why don't you again just correct it or add or amend it?" So he said, "No, I want to apply my fresh mind." So it is necessary for all of you to read your brief as many times as possible, because every time you read, you will get some different angle to the brief. And therefore, you will then try to see how you can put it the best way. Once I had gone to one of these topmost seniors and he told me that what you have to do is read the matter and keep it away. Then take a walk and keep on thinking about the matter. And then your ideas will crystallize. And then you are able to put it better so far as regards the court is concerned, so that, the court also understands it properly and you are also able to deliver it. Now, all of you know that there are 7 lamps of advocacy: honesty, industry, courage, wit, eloquence, judgment, and fellowship. Now, you will find commentary on all these 7 lamps in different books, and you must master them not only for the exam but in practice also. Now, so far as regards honesty is concerned, one need not go deep into it, because whatever brain tells you is honest. Whatever any other part of your body like heart tells you may not be correct. So always follow your brain. Now, industry, as I just now said, as much industry you put in, you will get the fruits, because that is a very important aspect of our profession. Eloquence comes from industry only, because once you get to know the facts well, you will be able to present those facts to the court. Then, of course, all these 7 things are there, and then comes the tact, which is the 8th thing, which the lawyer must possess. Because lawyer, it is necessary that he needs tact to handle any situation. Tact is art of all arts. It is the best thing when you have to listen to your opponent, when you have to listen to the court. You will find many advocates, when the judges are talking, they interrupt them. They don't allow the judges to talk. And you are at the receiving end then, because then the judge won't be able to tell you what he wants you to argue. And therefore, it is necessary that you must keep quiet when the judge starts talking. Now, you must master these 7 facets, 7 lamps very well, because in every exam there will be at least one question on these 7 lamps. It is extremely important. In my last lecture also, I had specifically elaborated on these 7 lamps, including the 8th tact. Now, your conduct with regard to the clients must inspire confidence. I can give you one example. One of my friends practicing on criminal side, this story is about 25 years back. He was with his client, he did his matter, and as he came out of the courtroom, some other gang people came with swords and tried to attack his client. He rushed to the help of the client and told the other gang people that the client is with me, I am doing his case, you do whatever you want outside the court, but here don't touch him. And the courage which the lawyer showed that time, you can imagine what must have happened to his client, and whether we in the present era today will be able to do even 10% of it, because we all hear that people go with automatic weapons and attack either other advocates or other gang members, and you can be at the receiving end. But this is the climax, this is the topmost honesty towards the client, and what the client must have felt, you can just imagine. Now, coming to conduct in the court, I have just mentioned to you how you should behave inside the courtroom, how you should answer the questions. If there is a question put by the lordships, you must answer them directly. You will, if you observe, there are so many advocates, senior advocates, who say that I will come to that little later, and then try to deviate from answering that question. According to me, that is not proper. You must first answer that question and then give your caveat to it. Like, at one stage in my junior days, the court asked me, my appeal before the High Court was dismissed for non-prosecution, and it would have been easily restored. But when the judge asked me, what is your defense? I was the defendant in that suit. So what is your defense? I said, my lord, my defense is adverse possession. So then the court said, no, we won't restore it. Let it lie there only. Because a plea of adverse possession, the courts usually are very slow in decreeing the suit on the basis of adverse possession. But the question is, when a question, the main point is, when a direct question is put by the judges, you must answer it directly. One of the very senior members, he was sitting by my side, and he told me that, well, you could have answered it any way you wanted, because then you would have got the relief what you wanted. I said, the judge asked me specifically what is my defense, then I can't go here and there, I have to answer directly. But that is up to you, and it all depends upon facts of each case. But I think that this is necessary, that you answer the question directly. Don't conceal any points from the court. You can press the best point, but don't conceal any point when directly asked. If there is a judgment against you, then it is better that the judges are informed that such and such judgment is against you, and therefore that law which has already been settled should be followed. Now, coming to the conduct in general, everybody knows that achieving success by hook or crook should be avoided. It is necessary that success is worth achieving at any cost is a bad proposition. Now, there are advocates who give interviews when the matter is sub judice. According to me, that's not a good habit, because the matter is sub judice. You don't know what is going to or likely to happen on the next date. So it is better to avoid the press. Usually when you draft petitions, you try to avoid adjectives, because the language should be simple as far as possible. Now, there is a proposition. If suppose you are asked that whether the advocate is a hired gun, you have to expand to say what you feel like, because it is not necessary that what the client instructs you, you have to tell in the court. According to me, you must say that he is not at all a hired gun, because he takes the brief of the client, he takes instructions from him, then he sees what is right, what is wrong, what is best in the interest of the client. But just because the client insists that he should argue in a particular way, that should be avoided as much as possible. Therefore, you can't term him as a hired gun. Now, how many times you people sitting in the court have found that the clients insist that we want to come to the court and we want you to address the court on 1, 2, 3, 4 points. Now, some of the points are not good. Some of the points cannot be stated. Then you must try to convince the client that these things will go against you and therefore they cannot be argued in the court of law. Now, unless you have proper written instructions, you should not enter into compromise. Now, there was a case when I was practicing in the Bombay High Court that I had challenged the bill, and there were 3 petitioners, and I argued it vehemently, and the court, seeing a junior arguing vehemently, asked the other side, why don't you pay each one of them about 25,000? So the other side agreed and the court passed the order. I was very happy that in 1976-77, 75,000 was a big amount. The clients would be extremely happy. But when I went back to the client came from Pune, and then they told me that no, we don't want money. We have to argue on merits only. Now, I did not know what to do. So I was advised that I should go to the chamber of the judge and tell him that I am in difficulty and I have put myself in difficulty because of this. Then the judge heard me and he said, all right, you come at 2:45 after lunch and mention the matter. Then when I mentioned the matter, he kept it on the next day and cancelled that order and set aside that order and passed order dismissing my petition. That time the judge said in the open court that Mr. Nargolkar, you have just entered the profession. Please remember that unless you have written instructions of the client, don't try to settle it. You will put yourself in difficulty. So always remember this, that unless you have written instructions from the client, don't settle on his behalf. Now let us come to another topic. Now this topic is about the section 35 of the Advocates Act. Now section 35 of the Advocates Act, it says about the professional misconduct and other misconduct. Let us read that section 35 of the Advocates Act. When on receipt of a complaint or otherwise, the State Bar Council has reason to believe that any advocate on its roll has been guilty of professional or other misconduct. Now this is the topic where in every professional ethics paper you will find one question, and it is necessary for you to read as many case law as possible and have your, according to me, you must have your own notes. When I appeared for my advocate on record examination, I had my own notes and I mastered them. Unfortunately, after so many years, I have not kept them, otherwise they would have been very handy. Now, what section 35 specifically says is, there are two conditions which are necessary. That the alleged to be guilty of, the advocate is alleged to be guilty of professional misconduct or other misconduct. Then that misconduct must be when he is a practicing advocate. And there are reasons to believe that he has committed it. Then the State Bar Council can take. Now, reasons to believe is, therefore, frivolous complaint should be avoided. Professional misconduct is unworthy to remain in profession. Other misconduct may be moral turpitude. So bona fide failure to notice subsequent amendments, etc., may not be a professional misconduct or other misconduct. But if there is dishonest intention, then it would amount to misconduct. If it is in respect of a matter before the court, then it would be a professional misconduct. Now, I don't know how you will look at it, handing over a brief to another lawyer without taking the consent of the client, because you are in difficulty, you are not in a position to reach the court, so you tell some other advocate that you represent the client. Now, if it is without taking the consent of the client, then that might put you in some difficulty. Now, if it is to be just adjournment is to be taken, etc., that's a totally different thing. Now, such charge of misconduct is a quasi-criminal in nature, and therefore the proof required is beyond doubt. Unless that much proof is there, the Bar Council would not take or punish the lawyer for professional misconduct. Now, there are cases where signatures are forged. There are allegations that the client says that my advocate has forged my signature. Now, when the matter goes to the court, the client is not in a position to demonstrate or prove that that particular signature is a forged signature, it is not his signature. Now, because it is required to be beyond doubt, then the court can't say that what the complainant is saying is right. Therefore, the lawyer can't be held to be professionally committing a misconduct. Now, there are various cases, if you see the case law, on the monies of the client coming in the hands of the lawyer. Now, there are Bar Council rules, Advocates Act. They say, at some stage, they say that, well, if the lawyer is entitled to his fees and the money comes to his hand, he can deduct the fees and give the balance to the client. But I can tell you one thing, that when I started my practice in Supreme Court, 2000 rupees cost have to be deposited in every matter when civil appeal, when SLP is granted. Now, after the matter is over, that particular 2000 rupees were given back to the advocate. Now, it was found by the court at that time that several advocates who would get those 2000 rupees refund would not repay it or pay it back to the client. And then thereafter, these people, they amended the our Supreme Court rules, and the check or draft was drawn in favor of the client. Now, what happens is 10 years, 20 years, 30 years pass by, and therefore you don't know whether the client is there, he is staying in the same place. So now, ultimately, that 2000 rupee deposit has been dispensed with. Now, there are several cases, and recently you would find them in the recent 2019, 20, 21, 22. All these cases, I think my learned friend has joined. So he will take over as soon as
No,
I finish.
I'm getting benefited by your experience.
What experience?
I'm listening to you very carefully.
You will say something after I finish?
Yeah, you please take your time. I only need them. They're all so well equipped.
Yes, no problem. I'm happy that you are here.
No, I had to be here.
Extremely happy.
You please take your time. I'll just take 15-20 minutes to share some thoughts which I have.
Now, so far as regards section 35 is concerned, you will find several authorities. Advocate who is found guilty of contempt may also be guilty of professional misconduct. On that, there are various cases, and you must go into these cases because they are very useful, they are very interesting, and you will be able to do justice to the question if you properly analyze them. Now, you would also realize that Supreme Court, High Court jurisdiction is different from Bar Council of the state and Bar Council of India's disciplinary jurisdiction. So, unless the matter first goes to the State Bar Council or Bar Council of India, then only the Supreme Court will be able to, or the High Court will be able to go into it. But therefore, these jurisdictions are different. So you have to spell them out properly. Now, what are the different ways in which the advocate can be punished? It's by suspending, revoking license, debarring him from practice. Now, you will find that advocates giving slogans in court premises, and the courts have said that, well, all these things are not proper and they must behave properly, and therefore it is necessary that these things are properly studied and answered in proper way and brief way in the answer books, which you will be now answering in the month of June. Now, so far as strike is concerned, now when we started our practice few decades back, I used to go to Dehradun to argue a matter, and it was an interlocutory application. So when I would go and argue a little while, the other side will seek and pass over. So the matter is passed over, then it won't reach before lunch. And when I go after lunch, I will find that the lawyers are on strike. Every day after lunch, the lawyers will go on strike. I asked them, why you go on strike after lunch every day? They said, we want a high court bench in Dehradun or Agra. Now for that, see how the advocates behave. They would take the brief, argue bail applications or interim applications, earn their fees, and after two, when other matters are required to be argued which may not be that important, they go on strike. Now, this conduct the Supreme Court has not appreciated at all, and you must go into all those judgments where, because now they feel that going on strike is absolutely wrong. You are taking a brief, you want to argue the matter, you have taken the fees, and then you don't attend the court is not a conduct which is appreciated by any of the court, the High Court or the Supreme Court. Now, they said that rarest of rare case, you can go on strike. Then the Supreme Court said that rarest of rare case, you can go on strike for one day. But not always. They found that Tisadari court.
Your sound was muted. So now you please continue. I think now we
Okay.
can hear.
But I did nothing, but it got muted. Thank you very much.
You are doing so much. Don't say you did nothing.
So, rarest of rare case, so you can go for strike for one day. Now, all these cases, now the court is finding it difficult that they can't justify the lawyer going on strike. Therefore, now the court says that the Bar Council of India, they must amend their rules. And a suggestion is there that so far as lawyers are concerned, if they go on strike, that should be taken as professional misconduct and action should be taken against them. So from that stage, we have traveled after so many years to this stage that the court is not allowing the lawyers to go on strike. You people might have heard about the atrocities done by the police on the lawyers in Tisadari court in that Kiran Bedi's case. So it all started from there. Even in Supreme Court, they asked us to go on strike. But we said that we will not go on strike. Then they tried to physically attack us, but we insisted that Supreme Court lawyers will not go on strike. So all these things must be taken into consideration. Now you must read all these authorities, M.R. Shah or Arun Mishra Justice. Both these judges have written a lot about them, and they have specifically said that the Bar Council should come up with suggestions and they should say that we are going to make them guilty of professional misconduct. So study these provisions very carefully. Now, one more interesting topic is about the professional communication under section 126 of the Evidence Act. No barrister, attorney, etc. be permitted unless with his client's express consent to disclose any communication made to him in the course of and for the purpose of his employment as such barrister, etc. He has become acquainted with in the course and for the purpose of his professional employment or to disclose any advice given by him to his client in the course and for the purposes of such employment, provided that nothing in this section shall protect disclosure, any such communication made in furtherance of any illegal purpose, etc. Now, you will see two examples which have been illustrations which have been given, and they are so akin to each other. A client says to the attorney, I have committed forgery and I wish you to defend me. As the defense of a man known to be guilty is not criminal purpose, his communication is protected from disclosure. Now see the second illustration. A client to the attorney, I wish to obtain possession of property by the use of a forged deed on which I request you to sue. This communication being made in furtherance of a criminal purpose is not protected from disclosure. So the line is very thin, but it is very distinct, and you must understand this properly so that you know what communication is privileged and what communication is not privileged. Now there was a case where the stock exchange gave certain documents to the person and tried to sue him, tried to file a criminal complaint against him. Now the Supreme Court said that you can't pick and choose. If you have to give, you have to give all documents, because you are giving him 3 documents and conceal from him another 3 documents on which also you are relying. So and you can't claim privilege that these documents need not be given to him. So such things should be avoided. But this is a very interesting thing, and in your syllabus this is specifically stated, and therefore I would request you to kindly go through this section 126 of the Evidence Act. Now similarly, amicus curiae also, what is amicus curiae? He is a friend of the court. Can he take a side of one of the parties? All these things are necessary, they are important, and here also Article 39A of the Constitution of Free Legal Aid also comes into picture. So if a question is asked on that, then you can give all these examples and case law and try to solve these problems. I think I have taken almost 45-50 minutes, and now I will ask my friend to conclude. He has more experience in the legal field and he is a charming person. Now you will enjoy his talk more than mine. Thank you.
Thank you, Nargolkar. You're always very, very kind and magnanimous. The first thing which I want to share with all my friends who are now due for the exam is wishing you all the very best, do very well and qualify. That's number one. Number two, I also had the privilege of becoming an advocate on record and getting a chance as a privilege to practice in Supreme Court. And I must say that I really enjoyed my tenure as an advocate on record, running around from one court to the other, from registry to everywhere, and learned so much. Now, first thing which I want to state is that you all are already advocates for at least 4 years, and also added to your 4 years experience as an advocate, 1 more year of training with an advocate on record. I will assume that to be a true fact, because we know that sometimes it doesn't become possible for everyone to actually grow through that training physically and actually. But yes, we will all proceed with the fact that at least 4 years in the profession and 1 year in the Supreme Court as training, which gives you a lot of exposure to at least understand what is the concept and phenomenon of an advocate on record. What I have learned and felt is this: it is a privilege to be an advocate. Starting from our history of independence struggle which we underwent, it was all led by the advocates. Becoming an advocate to excel in your career, to work for the society, to help in the administration of justice, according to me, apart from earning a qualification, it is also earning and conferment of a privilege. This privilege brings a number of duties along with it. So when I say that I became an advocate and I enjoyed a privilege, simultaneously there are few duties, at least 2-3 different directions. The first duty is to the court. When I say it is a duty to the court, then performance of your professional work in an honest and straightforward manner, that is the duty towards the court. The duty is to assist the court in coming to a right conclusion, and that duty can never be discharged if we are not straightforward and we do not come clean before the court. So it becomes our first duty to be a real, genuine help and assistance to the court. The second direction of duty is towards your client. And the duty towards your client is that with the best of your ability and knowledge in the branch of law, to understand the problem and the legal issues in which your client is entangled, applying your mind and your knowledge how to find out a solution, and doing everything possible at your command to place it before the court, undergo that adjudication process with your expertise, and then wait for the outcome which takes place. That is the second duty toward the client. The third direction of duty is duty toward the other side. So when we are duty bound firstly to the court, we are duty bound to our client. As an advocate practicing in any court, including the Supreme Court, we have a duty toward the other side. Other side would mean that if I am doing anything, I file anything, I don't file it without giving a copy to the other side. If I agree with some kind of an arrangement to be reached before the court, whatever I have agreed with the other side, I must remain honest and truthful to that in the court. I should not throw up surprises to the other side contrary to the understanding which we had either a day before or earlier between us. That is the third duty. That is the third direction of duty. So while enjoying this privilege, we must remain completely dutiful to our client, to the court, and to the other side. And then there is a saying which we all have heard, that if a situation comes into an existence that you may lose a case, then don't lose a client. And the second stage of situation is a situation come that you have to lose a client on one hand or to lose the court, then it is better to lose the client and never lose the court. Now, after having said that to become an advocate and practice as an advocate itself is a privilege, advocate on record is a next privilege which is conferred by the Supreme Court on your qualifying this examination. And one feature which I have seen and learned and experienced, Supreme Court, Mr. Nargolkar has much wider and larger experience, he knows, is only one court where orders are passed without there being any paper, any application, any petition before any of the bench of the Supreme Court. Orders are still passed. And what is the basis of that order getting passed? A complete trust of truthfulness of what the advocate on record orally submits before the court. Supreme Court is one court where you have still to file a case, but a situation has arisen that you need urgent orders. Walk into the court number one, even at about 4 o'clock when they are rising. Tell them orally, as an advocate on the court, sir, this is the problem which has happened. It calls for an imminent, urgent intervention of the Supreme Court. Papers are not available, papers are not ready, but orders are needed. At that time, it is the trust with the advocate on record or the straightforwardness and honesty which he has earned over a period of time. He makes an oral statement and orders are passed. This is the return which every advocate on record who gets qualified is to give back to the Supreme Court, that trust, and generate that trust that if any advocate on record makes an oral statement before the court, the time which then comes thereafter proves that that oral statement was absolutely true, because the Supreme Court will not wait for the paper. It does not require to complete the formalities for passing of an order. The orders will be passed, but they are all dependent upon the trust which the lawyer as an advocate on record has generated. This is what we earn, and we must earn after we get qualified as the advocate on record. Because in all other high courts and trial court, you will find whenever any even urgent situation arises, you go before the court will say, no, sir, please come up with your petition. I can't pass orders in here. But Supreme Court will say, please take this order and then bring your petition tomorrow. I believe your word. So advocate on record is that one institution, one class of lawyers who are given that privilege by the Supreme Court on their qualifying the exam, but this trust is to be earned by every one of us after we qualify in the exam. So our earning and our belief and our every act which we undertake as an advocate on record must also be towards building up that trust with the court. Having said that, and keeping in mind that the syllabus is circulated, the number of judgments are circulated, what I have done is, in addition to the erudite speech which my learned friend Mr. Nargolkar has given to give you a little familiarity with your subject and the paper, I just want to say one thing. I had the benefit of one of my colleagues in my chamber who has appeared and qualified in the advocate on record exam this year, to take the benefit of his work on this subject as an advocate on record candidate. And I'm going to share it on the screen, my way of looking at the curriculum which has been prescribed for you and which has been circulated by that notification of 19/4/23. We have divided into a different portion only for your broader understanding. We have also given a one para note on each of the judgment from the perspective of your exam, and we will request you to kindly run through your judgments fully as a case material, because when I was studying my law in the Campus Law Center, Delhi Law Faculty, according to me, that one of the best methodologies is the case material system, that your course which is having a number of judgments, so you are given the judgments as a material to you, and you run through your judgments and you are ready for the exam. So there are about 41 judgments which have been prescribed in your curriculum. What we have done for your little assistance and your help, that we have broadly, though one judgment may involve 2-3 points, but whichever judgment is predominantly on any particular issue, we have broadly divided those judgments and segregated under different issues. And we have put it there, and what we have done is that the soft copy of each of the judgment in that order is appended to that little small note of some 15-16 pages which we have made for your perusal. And I have requested my colleague Mr. Prabhat Bajaj to hand it over to the Supreme Court Registry, to the Advocate on Record Examination section, if they can put it on the website. And I'm also told that there are a few WhatsApp groups where everybody is mostly connected. So we will try to put it there on that also. So please keep one or two things in mind. For the purposes of understanding and appearing in this examination, in addition to what Mr. Nargolkar has broadly and with his experience on explanation of some aspects has already brought to your knowledge the approach to be adopted in the present case, kindly keep one or two things in mind. The first thing which we have to understand and go through is the relevant provisions of the Advocates Act. The starting point for the present purposes is the Advocates Act. Chapter 5 of the Advocates Act is relevant for your purposes, and I requested my colleague Mr. Bajaj to put that chapter 5 as one of the annexures to our note, which becomes readily available to you, and you need not run here and there for any book, etc. So Advocates Act 1961, sections 35 to 44, we will put it at one place. Then there is chapter 2 of part 6 of the Bar Council of India rules. So we all know that the Bar Council of India, which is the supreme body, not only to give us the enrollment through the State Council, but it also lays down the rules towards the conduct of the professionals in the profession of law and to be regulated through the State Bar Council. So the Bar Councils at the state level give us enrollment, and they also remain bound to take remedial action if we indulge into any misconduct. So there are two purposes for the Bar Council, etc. First of all, lay down the norm for the proper good conduct of the lawyers, and then be there to take action if that conduct is violated, is violative of the basic duties. So therefore, the first thing which is to be gone through and we must make ourselves abreast with is chapter 5, section 35 to 44 of the Advocates Act. Then chapter 2, part 6, in which Bar Council of India has framed the rules. Prabhas, if you just share it with that on the screen. This note, I'm going to put it to you immediately after I close. So first thing is the Advocate on Record, which is earlier there in para 4. In para 5, 4 is the Advocates Act, where it is mentioned 35 to 44 in chapter 5. Kindly see para 5. This is the standards of professional conduct and etiquette, which is laid down by the Bar Council of India. So kindly go through it, because this is, I'm only saying the privilege is by the under the Advocates Act by the Bar Council of India and the State Bar Council. So they also lay down, while exercising their jurisdiction on us, which flows automatically through the process of enrollment, is to keep our conduct under verification and check. And there, the Bar Council of India has also laid down standards of professional conduct and etiquette, which is a part of what we broadly call is ethics, which we have to follow. And kindly keep them with you. We are going to put it at one place. Please be, because they are readily available, kindly go through them. Even if we have made small notes of the judgment, but the request is that it would be advisable that kindly go through the judgment. They would be interesting reading also, because these judgments on these points of ethics and professional conduct are primarily fact-based, and the principles have been laid down there under. It would be interesting reading as well. Now, if you see those principles which have been laid down, which I have already very broadly mentioned: duty to the court, duty to the client, duty to the opponent, duty to the colleagues. After the duty toward the other side, duties in the same bar association is also towards everyone. Then other things about your contribution to the welfare fund, imparting legal training, rendering legal aid. Then you have not to look for employment or go for your advertising, etc., which you are aware, and that is also included here. Then comes, after the Advocates Act, Bar Council of India, rules framed by Bar Council of India. The next stage is Supreme Court rules. So the Supreme Court rules provide broadly for some norms for every advocate who seeks to practice in Supreme Court, and the institution of advocate on record, which is a precondition under various of these rules. These rules are of 2013. They are under Order 4 of the said 2013 Supreme Court rules, and they also incorporate various duties, responsibilities, after extending that privileges to the institution and the concept of an advocate on record. Then please see after, so Advocates Act, Bar Council of India rules, and then the Supreme Court rules. And all these three nomenclatures and three parameters, regulatory mechanism, which is under the Advocates Act and the Bar Council of India rules and the Supreme Court rules, we have taken now a analysis of various judgments which are included in your course content, and for your reading to be made easier, he has my colleague has put one paragraph each on each of the judgment which is included in this note, with the clear request to all of you, once your interest gets aroused in the each judgment, please kindly go through that judgment fully on your own, and the soft copy of the all judgments is going to be appended with this note. Now this in this section, which is violating the confidence of the client. So when you have a duty as an advocate as well as an advocate on record, because these duties which are mentioned here as an advocate on record toward the client are also the duties of every advocate. But the Supreme Court is ready to pass order even on an oral assertion of an advocate on record, but that is what the privilege they confer. Now, for an example, this case of Rangadurai of 79, the fee is taken for filing more than one cases. Only one case is filed, but the client was informed that I have filed all the cases. Obviously, you are losing you are violating, you are playing with the trust of the client. And that is a clear violation of our duty. Then if you take the second example of Khandekar, which is 84 of Supreme Court, a false affidavit is prepared by the advocate by giving the wrong place of the solemnization of marriage, knowing fully well that it's a false statement, and then the consequences which flew out of that, they have been analyzed by the Supreme Court, and they held it is not only negligence, but it is also touching the area of moral delinquency, and it was held to be a case of professional misconduct. So I'm not going to run through all these cases which we have now put category wise, and I'm saying that one judgment may have overlapping principle from one category to the other, but we have predominantly put one judgment which is with regard to that principle. So first part is when we go astray and violate our duties toward the client. The second part is when we go astray and violate the duties toward the courts. Now here, the advocate of the petition in this case of S.J. Chaudhary, Lieutenant Colonel, was not ready for day-to-day hearing. So then the principle laid down is the duty of every court to accept a brief if on the assumption that if day-to-day trial is to take place, the lawyer will not be able to say no. And if he says no or does not do so, doesn't attend the trial on day-to-day basis, then it is a misconduct. Then without authority of the client, to what extent you can act. So there is this judgment of Bairam Pestanji Gariwala. What had happened was that in the Wakalatnamas which we sign, which is a condition of engagement of a lawyer, it is always written that a lawyer who's engaged, he would also be authorized to settle a matter even on certain things which are not the subject matter of the case which he is doing. But that implied authority, it has been cautioned, must be with the knowledge of your client. You may do so, but if supposing some misunderstanding comes into existence, which has the effect of impacting your trust with the client, or the client may lose trust in you, then it is, even though you have that right to do so, it is always advisable that you do that with the knowledge and consent of your client. So therefore, how much you can do with any kind of an implied authority is also taken note of by the Supreme Court, and the principles have laid down in this regard. Then professional or other misconduct of falling into different kind of category is also one particular classification which we have tried to do in this note, and various judgment with, for your convenience, with one para to give you an indication that on what subject the judgment has been put. Similarly, professional negligence, like medical negligence, there are also cases that you have acted negligently, not that you had some ill intention. And if you see in this case, he gave a wrong advice regarding encumbrances on the property mortgage to the bank. As we all are aware that supposing the bank has to give loan, it has to get securities. Securities may be immovable. So the bank would insist for the document, send it to their lawyers and ask them, sir, please tell me, will it be a proper security or not, etc. And on that basis, give their advice. Now, some of the cases where even when the advice has been found to be not correct, it has not touched the domain of professional negligence, so that if the CBI is to register a case, they have tried to register the cases against the lawyers as well of the bank. The Supreme Court has said no. This may be a wrong advice, but it is not that kind of culpable negligence on which you can take a case against the lawyer. Now, these are areas which we must be conscious and aware of. Then there are a number of cases with regard to misconduct on the allegation with regard to fee. And there are judgments which say, supposing I am doing a case, I was taken a fee in part, I am continuing to do the case, but the rest of the fee is not coming. The question arose, can I keep on possessing the documents of belonging to the client on the condition that no, you pay me my fee first and I will return your papers to you later? We can't do that. Not done. It's not permitted. And the judgments which are there on the screen, they directly go on to tell us and guide us that whatever duties and whatever rights in this regard. Then the lawyer should not have personal interest in the subject matter of the litigations. We tend to, if supposing I'm dealing with a property cases, sometimes we tend to say, oh, why should I not buy that property? Never do that. Never no, please don't allow yourself to permit entangled with creation of an interest willy-nilly. You don't realize it, but you then find yourself to be having possessed with some interest in the litigation. Please don't do that. That's not allowed. And then obviously misappropriation of money is a misconduct, not only as a civil misconduct, but a criminal misconduct everywhere. Then there are cases of physical assault, which are also a subject matter which is interesting to read, but we should always be aware of. Then there is one area of professional misconduct on one hand, contempt of court on the other. Then Mr. Nargolkar was pointing out to the judgment, famous judgment of V.C. Mishra in relation to Bar Council, where the Supreme Court, first of all, they said, we will also hold them guilty of misconduct on some area. But on a review, it was changed and they said, insofar as misconduct is concerned, that is that Vinay Mishra's judgment, it will always remain within the domain of the Bar Council, who is a statutory regulator. However, it goes into the area of contempt, then that contempt jurisdiction will be vested with the courts. Then there are these judgments where Article 142 with regard to the professional misconduct and to deal with the advocates are also included, course curriculum. Then designation being taken away in one of the matters which is on the screen, that counsel was found to be tutoring the witnesses in a criminal matter which is very popularly described as BMW hit case. So where the Supreme Court had upheld the order of the High Court, where perhaps unfortunately a designation was taken away because of that finding, and that also is a part of your curriculum. Strike we have all seen within our 4 or 5 years of fulfilling the eligibility to sit in the exam. There is law which has been laid down more than adequately on the strikes and its relationship with the allegation of misconduct by the lawyer. Mr. Nargolkar has very, very eloquently informed us of the legal nuances cause strike. Obviously, we must be away from it, but sometimes they become inevitable and we are compelled to resort to that, but then we also expose ourselves to the consequences which can follow. Then something which has to be always avoided unless there is a truth, because if there is a truth, we must do everything possible. If there is something going on, some area where registry is doing something, that also is to be spoken about, but the various judgments have also laid down, like for an example, if in the hierarchical system of our jurisprudence, if the lower court judgment goes to the to the higher court, then the principle is that the higher court will have a say on the judgment, whether the judgment is right or wrong, but the higher court would be well advised not to make any adverse comments against the judge who decided that. Because it's a process where my understanding may be different from the understanding of somebody else. I may be right to my understanding, but the higher court may have a different understanding, and the topmost court may still have a different understanding. So you set aside the judgments, you don't make observations against the judges. Similarly, I may have a different understanding, but that is not always subject matter of criticism, and that the principles of law have been laid down in this regard. And one area which has always remained a gray area, and today in the present world of digitalization, OTT and computers and social media, how much we are able to control or live within our original thoughts and understanding of advertising and solicitation. This is one gray area where the law would continue to develop, that what would constitute advertising, what would constitute solicitation with the advanced technological tools now, and that area we will see. But the basic principles remain that in our profession, it is not permissible to advertise or to seek or solicit work which is not a bona fide and a proper source of generating work. Then amicus curiae, Mr. Nargolkar has explained, some judgments have been included in your course curriculum, and small little indicative notes have been put in this brief description which we have prepared. Then duties of AOR which are mentioned, attorney-client privilege, Mr. Nargolkar has already mentioned, which is incorporated in section 126 of the Evidence Act. Several lamps of advocacy has already brought to your knowledge. And then the last part is mediation and conciliation, which has become which has now also got a statutory color. It has been incorporated even in the Civil Procedure Code and various laws. Mr. Nargolkar has pointed out to you that also becomes a part of our duty now to see if there is a mediation or conciliation is possible. We should try to curb our own feelings about that, and if the court, if the case is coming to an end through the process of mediation and conciliation, it also remains our duty to facilitate any such process. Now, toward the close of my interaction and dialogue with you, at the cost of repetition, this note is being sent to you. Kindly write every question. Please don't leave any question. My very humble suggestion to everyone, every candidate is, you may compromise with the quality of your answer to first question or second question, but please ensure you have attempted all questions and you have answered them. You may compromise if your handwriting is slow. You may compromise with the quality with your first 2-3 questions, but ensure that you have completed all your 5 questions. This is one thing which we must keep in mind, because in papers like drafting, you will realize that since you are not writing with your hand, your one affidavit or one petition may take 3 to 4 hours, and you realize that you have done beautifully well in one answer, but 4 answers are not given. So even if you get 20 out of 20, you still don't pass. So kindly complete your paper fully. Please answer every question. Please distribute your time in such a manner that when you get up at the end of 3 hours, you are happy and satisfied that you have answered and attempted every question. And there is a prize which is to be given to the candidate who tops the exam and who comes second. So let us see who becomes that lucky one amongst you when Mr. Nargolkar will announce your result after the exam is over. I would only wish you all the best and kindly do well. Thank you.
First of all, let me come back. I don't think any other lecture is necessary on professional ethics after this note is given to all candidates. Please circulate that note to me. See that I receive it. Next time onwards, I am not going to prepare anything. I will just read the note, if at all I am there.
Mr. Nargolkar,
You have done an extraordinary job. Your junior has to be given that credit. And because you told him, he has done it. So all credit to you. And all the students who have attended today's lecture, as well as those who have not attended, will be highly benefited. So I am extremely happy that you have done that job. So they don't have to go here and there to find out what it is.
but it's only a note with the humble request once again at the cost of repetition. Please go through your syllabus and judgment very carefully. They are extremely interesting. They teach us so much, and that learning will help you throughout your professional career when you are positively going to qualify.
Absolutely.
And I will request the Supreme Court Registry, and this is only an analysis of your, we may be wrong. It's only analysis of your syllabus. We may be wrong. Therefore, please go through your syllabus and judgment very thoroughly. We have only tried to help you by such a preliminary kind of analysis, giving you a broader perspective in what manner your course has been subdivided. That's all. So kindly go through your
You are
syllabus.
more than humble. It is not necessary. I think you have done a fantastic job.
I hope it benefits everyone. So I'm going
It will more than them. It will benefit me.
so that would give meaning to the hard work Mr. Prabhat Bajaj has done for me. Thank you very much. And
शाबाशी मेरी तरफ से उसको देना.
wishing you, Prabhat, you come here, Baba, so that everyone sees that you have also qualified only this year. Mr. Bajaj is a Prabhat Bajaj is a software engineer first and then lawyer later.
Oh, great.
Sir, all the best. Thank you very
Thank
much.
you very much. All the best to all the
Very well.
students who are going to write. And I'm sure now you will come with flying colors.
They are otherwise
Thanks.
about to come. All the best to them. Thank you.
Thanks.
Thank you, sir. Thank you very much. Thank you so much, sir.